And we are live. Good afternoon, alienated parents, grandparents, children worldwide, professionals, specialists out there, therapists, lawyers, judges. Please tune in to our today's podcast with my special guest, Mr. Gene Coleman, family law from Toronto, Ontario, Canada. Gene has been a guest before on Let's Talk, Real Talk. So this is part 2. And Gene specializes in gender-based procedural fairness, helping parents to maintain relationships with their children. I mean, this is so important when parents are going through divorces, separations, on the importance of children having both parents. So I welcome Mr. Gene Coleman. Thank you for coming on again. And we really appreciate all your knowledge and expertise on family law. You've been since 1979 to present as a family law lawyer. Man, you must had a whole lot of problems and God knows what else.
Yes, a few, thank you. Yes.
Yeah. And here you are. You're still here. You survived it all, and you're helping families all over, not just here in Canada, but people watch you from all over the world. So tell me a little bit about your background yourself. I mean, before we get into, I just got a few questions I'd like to ask you, as I know you're very important. Time is, valuable, and don't want to keep you too long. So give us a little background on family law and parenting.
Well, thank you for the introduction, Mary. And don't worry if we go a few minutes over 30 minutes, or we go 45, or even if we go an hour. I will make the time, because the work that you do is so important. I couldn't believe how many podcasts you do. That's incredible, and your dedication is very commendable. As you mentioned, I've been a family law lawyer since 1979. And I started doing family law cases during my second year at law school. So that was 75, 76, as part of Osgoode Hall's community legal aid clinic. And some of my first cases were with Jeffrey Wilson, author of Children and the Law. Great text that he wrote. It progressed into a loose leaf. Later, I reviewed both, and Jeffrey and I had been turned out to be close colleagues over the year. He's retired now. So I started Jeffrey was 1 year ahead of me in law school, and I started under his mentorship, and learned a lot. I had the privilege to have other mentors during my career, such as the late Justice Patricia Wallace in Hamilton. She wasn't a judge when I worked for her. She was a regular family law lawyer, much like I am now. And then fairly early in my career, I had a case, B versus B. I won't give the names, though it's easy enough to find in Canley. And my client wanted equal shared parenting. Though back in those days, in the 80s, we called it joint custody.
Mm-hmm.
And I said to him, well, we've, there's 2 Court of Appeal precedents that are standing against us. And so if you're serious about this, you've got to prepare to lose a trial and take it on appeal. And I have some pretty good arguments in my mind that we could make now and distinguish your facts from those facts. And he says, sure, I want to go for it. He felt very strongly. And we went for it, and we succeeded at trial. And it became a precedent-setting decision under the then newly amended Divorce Act. And that created quite a wave, and I started getting invited to speak. I spoke at a group called HEART, H-E-A-R-T, in Toronto, and I spoke many times for Fathers Are Capable Too. Fact. And I was very privileged to speak to fact from time to time, but I learned more than I gave over. And I started really talking to guys before my presentation, after my presentation, fielding their questions. And little by little, I became an advocate for joint custody, and now, as we call it, equal shared parenting. I want to thank the leadership of FACT. If any of you are watching, hi. I am really grateful to FACT for sensitizing me to the issues. And I've become an advocate, and I help to then organize a number of organizations such as CPIC, the Canadian Equal Parenting Council, and as a coalition of organizations across Canada dealing with, as we call it then, joint custody. And it's become my life's work. It's become my life's work. I feel passionately about it. So the clients that my firm tends to attract are those that want equal shared parenting. And so in my firm, we advocate on the micro level, that is, individual cases. And on the macro level, I have been very active in years past in leadership roles in the equal shared parenting movement. I guess the highlight of that has been my address to the Justice Committee of the House of Commons. I think it was actually a joint Senate House committee headed by still MP Anthony Housefather, MP from Mount Royal riding in Montreal, a Liberal.
Mm-hmm.
And I thought he did a great job of chairing the committee. He was very courteous to those like myself speaking. And I was able to deliver a talk to the committee members. And George Peascore and I prepared a paper, a largely academic paper, though of course many practical aspects, proving, I felt, beyond a reasonable doubt, to use the criminal law level of proof, if I might, that equal shared parenting is generally speaking in the best interests of most children. Of course, you can't have one law, equal shared parenting, in everybody. It's not appropriate for everybody. But all things being equal, it's appropriate for most. Now, the bill that Parliament was considering back then did not have an equal shared parenting provision. But I spoke about it, and Brian Ludmer, you know well, he also gave a presentation, an excellent one. And even the late John Sirtash, who was not particularly, was a good friend of mine. His loss is severely felt to this day. Even he came out in favor of some sort of equal shared parenting rebuttable presumption, which he surprised me when he did. And so that was the highlight, I think, of my efforts. Since then, I have drafted a proposed amendment to the Ontario Children's Law Reform Act. Myself and Brian and George, we together, I won't take total credit, it was a group effort that we did, and we are trying to get that amendment and a similar amendment to the Divorce Act to be considered by Parliament. Of course, we want the provincial legislature here in Ontario to deal with it. Of course, any advocates across the country. Brian and I are at your, you can ask Brian. Brian Ludmer and I are at your service to share our statutory amendments with any committee, anywhere else in Canada. And it's a simple amendment, very simple amendment.
Doesn't take much. Yes, Brian was on Let's Talk, Real Talk as well, and great podcast with him too.
Yeah. So, Brian Ludmer and I, George Peace Corps has been a mainstay of the movement for decades, as has Brian and myself, and many others like you. And along with this comes parental alienation. You mentioned introduction that I gather a large part of your audience consists of alienated parents and alienated grandparents. And that also just sort of went hand in hand. My issues are equal share, rebuttable presumption, equal share parenting, parental alienation, and procedural fairness. And I've talked too much. Please redirect so I am more focused.
No, you could never talk too much.
Not all judges agree with you, but okay.
Oh, well, that's them. They got a lot to learn.
I would say that not just because during my day I have been shut down by some judges that are frankly rude, in some cases frankly anti-Semitic. It's been a challenge. I was told once to take my kippah or skull cap off during a court hearing. So yeah, but still, I'm trucking on and trying to effect change on a macro level, systemic level, and try to secure justice for fathers and mothers, I might add, and mothers, mostly fathers. That's my practice, and help to bring some small measure of sanity into this world. And how do you have sanity? Children have a right to a relationship with both parents, notwithstanding the marital status of the parents, notwithstanding were they ever married, divorced, maybe they never even lived together, they just got together on at least one occasion to make a baby. I think this last year you had to do that. Hey, now with in vitro fertilization, you don't even have to get together in that sense. And there are those sorts of cases too. People go ahead without doing the proper paperwork beforehand, and then there's disputes afterwards. So I do what I can on both the micro and the macro levels, and whatever time I have for my law practice, I'm still going strong. 75 years of age.
We're grateful.
Thank you. I enjoy it, but thank you. But so the pro bono work that my firm does, myself and others in my firm, I have a great team, is on the macro level. I often get approached, Mr. Coleman, please take my case. I don't have any money, and by the way, my firm unfortunately does not take legal aid. It just I'm sorry, it's a business as well. You're not able to survive financially on legal aid. So I don't take legal aid, and we try, for such people that inquire to our firm, we try and give them resources. We give them online links for them to check out and refer them to the Law Society Lawyer Referral Service. And maybe I'll give a few words of general advice and do what I can to help people, but we do not do pro bono cases on an individual level. It's not that I don't want to, I would love to, but last I checked, there's only 24 hours in the day, and you have to use some of them to sleep. And so whatever time I have, I've been pushing for law reform. And I've dedicated myself and my firm as well, lots of help from my firm members, to try and get a rebuttable presumption of equal shared parenting.
And I bet you appreciate the advocates out there who support the equal share parenting as well, because I mean, the advocates are the ones that have to deal with losing their children. A lot of advocates out there haven't seen their children in 20 years. This is so sad, because we have seen our children grow from an alienated child but beforehand they were healthy, to being adults that are severely traumatized, no different than a domestic violence survivor, right? I mean, they're held by the same captives if they do take the child away from the other parent.
Well, okay, so let's talk about parental alienation then, and let me. I agree with everything you stated, but let's try and put some perspective to it. So, okay, not every case that on the surface you and I would say this is a case of parental alienation is true parental alienation. Human relationships are complex, and sometimes there is estrangement between a child and the parent. And just because there's estrangement and there's tensions in the relationship, or a 15-year-old doesn't want to go to mom's house anymore, doesn't want to go to dad's house anymore, or wants to change the previous 50-50 arrangement, only wants to go every weekend or every second weekend or whatever, it wants to go back. That doesn't mean that the other parent is a bad parent. It might be. Yes, you have to test the hypothesis. It might be. But there might be other factors at play. And we have to be aware of that. You can't, if a child is refusing contact with a formerly beloved parent, it doesn't mean ipso facto, use a bit of Latin, in itself, it doesn't ipso facto mean that one parent is alienating the child. In the cases that we have in our office, believe it or not, unlike our website, we don't plaster the words parental alienation all over the affidavit material or the case conference brief, the settlement conference. We don't do that. Hey, Coleman, you're a big PA advocate. Why do you use the word parental alienation? Oh, I'm glad you asked that question. Let me tell you. It's become so political. It's become toxic to use those words. Of course, we all know that the radical elements within the legitimate feminist movement, but within the feminist movement, say, oh, he's claiming parental alienation because he's really just an abuser. And he's using it as a shield and a sword and a counterattack against poor mom, and he's just abusing her. And that's why he's claiming parental alienation. Well, you know what? That sometimes happens. But more often, you've got the allegation of it. And the whole thing has become politicized. So you've got the men's groups on one side and radical feminists on the other side, and many academics siding with the latter. And the term parental alienation becomes toxic. And don't think for a second that it doesn't rub off on judges. They read newspapers, they read magazines, they read articles, and it's going to rub off. Well, how do we get around that? Here's what you do, folks. You describe the behaviors. You describe the behaviors that you observe in the child. So when a 6-year-old comes out and tells you something that obviously had to come from mom or her parents, for example. Okay, I'd be careful. It could be dad and his parents. I'm just using one gender or the other. And the wording is far beyond the normal vocabulary of a 6-year-old. Well, sounds like it's coming from mom's house. But don't write that down. Just say, when I had my child with me last weekend, 2 weekends, whatever, this is what he said. Don't go to and that shows she's guilty of parental. Just put it down, low key. This is what he said. When you get your child and your child then is very standoffish to start off the time with you, just write that down. Describe the behavior. Invariably, in cases of PA, what happens, as the child is with you for longer periods of time, the child starts to warm up. And by the weekend, by Sunday afternoon, the child doesn't want to go back to mom. Just describe the behaviors. Now, if you're using Our Family Wizard or a similar platform for communication, or even if you're still in the dark ages using text messages or emails, whatever your mode of communication is with the other parent, number one, be careful what you write. But what the other side writes, that's direct evidence. So if she writes to you, you are a piece of you know what, and you don't know anything, and you're terrible, and then attacks your parenting and makes stuff up, there you are.
Mm-hmm.
That's evidence itself. Do not write back to the abusive former beloved of yours. Well, you're a piece of you know what too, and you did this and you did that, and don't do that. You think a judge is going to be impressed with that? You think a judge is going to be impressed if you swear and use profanity? I'm amazed when I see what our clients have written before they retain us. Just like amazed. Don't go down to her level.
Drip love.
Keep it civil. Keep it focused. And if there are 10 allegations there that she's making against you and they're all false, just say, I'm sorry you've perceived matters that way. That does not accord with how I see things. We'll have to agree to disagree. Then you are improving the co-parenting relationship by not taking the bait to fight
Right.
like, and you are in the process creating admissible evidence that will hold you in good stead. And I wouldn't even use, and don't say in your message to the other parent, you are a terrible parental alienator. Don't say that. Describe the child's behaviors. How can we work together so our child doesn't experience the stress in coming to me? How can we help? Would you agree to go see a mediator experienced in these matters? Maybe we can talk it through and find solutions. Like, propose reasonable things. Don't just think that I've seen this so many times, don't think that you need to have the last word. I mean,
who would you recommend families to go to solve these issues before it gets into the courts? Like, how you catch the child not wanting to come with you. Would you recommend a therapist?
yeah, I would. I'm not going to give any particular recommendations.
No, but would it be a complete family, a whole family?
Don't go to just anyone. It has to be someone that has experience and expertise with intra-family conflict where parents no longer live together.
Right.
That person has to have that sort of expertise. I mean, in this day of the internet and AI and all of that, you can easily find online therapists that have that sort of experience. And you're going to look for recommendations. And if they're a friend of Mary Auld-Kovacs, then write Mary and ask her, hey, who have you heard is good these days in Sudbury and Timmins and Toronto and Mississauga, whatever. Find out from people like Mary, who are the leading people in this area now, and do your own research. And since our separation divorce rates are so high, I'm sure you have friends and family that have gone through the same sort of thing. Ask them. If you have a lawyer, ask your lawyer who the lawyer is. I know in our firm we use a relatively small number of people that we send our clients to for individual therapy to help them deal with the excruciating trauma of the family law system. And then there are people that we use for mediation. There are people we use for combination mediation arbitration. It depends on the situation. But on the first level is get some sort of family therapy. It doesn't mean the parents have to sit in the same room together the whole time. There's various models of therapy. Some people aren't able to do that, but of course you
Right.
want to be. Of course, you want the therapist to eventually be able to bring the two parents together so that they can talk civilly. 15, 20 years from now, you're going to have, God willing, a wedding, a christening earlier,
Grandchildren.
a bar mitzvah, a bat mitzvah, whatever. You
Mm-hmm.
can't turn these, what should be happy events, into war zones. And I'm not saying you, listener, viewer, are the bad one. I'm not saying that. I say you generically. Don't. And if the other parent is sucking you into this conflict, do not take the bait. Do not take the bait. There are therapists, counselors around that can give over all this information that I'm giving over. I know for our male clients in particular, there's one fellow that we tend to refer to because he's a doctor of social work, very experienced, headed up a social work services at a child protection agency for a couple of decades. He left them and went on into his own practice, so he knows the court system very well. And we send our male clients to him, and they seem to connect, and gives over, I'm sure, the sort of advice that I'm giving here. Don't get sucked into the conflict, people. Don't do that. You're not doing yourself any favor. Totally aside from it's going to tear your insides out.
Oh.
Totally aside from that. So giving good advice. Don't let your insides be torn out. Go above the conflict. Get professional help. Ideally professional help to both parents so that you could become the best parent you can possibly be.
Yes, it is very hardening for alienated parents not to go to the kids' weddings, not to see the birth of children, not being able to, be grandparents, or great grandparents, because it's a generational curse when they hold back.
You mentioned grandparents and great grandparents. When you cut off grandparents, and it happens sometimes one spouse dies, and then the other spouse, let's say the wife dies, but the father doesn't get to take over the parenting. A step parent does, or someone else does, and for whatever reason he doesn't take over. And then they exclude that father after the wife's death. And of course, it can go both ways, folks. Exclude him. That's half the child you're excluding. And not just the father, but the whole family history and storytelling and the whole thing. Thank God I've been married to the same wonderful person now for many years. Actually, tomorrow is our anniversary. I have to do I think it's number 54, 53.
The anniversary.
Thank you. Tomorrow is our anniversary. I'm very privileged. We have 7 children together, many, many grandchildren. And, when we get, and over the years, we get together for family get-togethers, meals, whatever. And I invariably tell a story that I have told when I've given seminars to grandparents. I tell the story. I won't tell the whole story. It'll take too long. But I tell the story about, it turns out, I tell a story about a young man and everything. And it turns out at the end of the story, I let everyone know that was my maternal grandfather, who was the protagonist in the story. But it's a whole family history. And I give over this history. And my grandchildren and my children and my grandchildren have absorbed that. And when you cut off a parent, there's none of that family history. Like you leave the child with an emptiness. And grandparents are very important. And I've been saying that since before I was a grandparent. Now that I'm a grandparent, I very much say it. And my grandchildren want to hear these stories. And my wife and I are privileged to share the stories about the family, about our parents, about our grandparents, and about their parents too. They like that.
Yeah,
They like,
there's nothing greater than grandparents.
you cut out the parent. But one thing I say in my talk to grandparents, and by the way, my talk to grandparents is available on my website, complexfamilylaw.com. Go to, I think, events. There's an events subfolder there, and then there's a list of the webinars that I gave, a lot of them during COVID. There's the grandparent one. You can hear my story, but that I just mentioned, and I lost my train of thought. Anyways.
But the grandparents, thoughts of grandparents.
Yeah. So, oh yeah, grandparents. Thank you. So my message here is be a peacemaker. You may not approve of how your daughter-in-law or son-in-law deals with the children, and you may, objectively speaking, be right. But you are the grandparent. You are not the parent. And it's something I often have to say to myself, because I see in my kids, I think those that are parents, I think they're great parents and far better than I was. And but I sometimes have to hold myself back, and I'm thank God, in an intact family, not a separated family. But you have to remember, grandparents have to be peacemakers. Our job as grandparents is simply to spoil our grandkids. That's all, and love them unconditionally, and pass along family history. That's our task as grandparents. Not to tell the parents how to behave, even if you are right.
Mm-hmm. There's a saying: if mom or dad says no, go see grandma. My kids had that T-shirt on, and they valued their grandparents too.
As a grandparent, you have to stand behind your child and that child's spouse, even if they are ex-spouse. You cannot contradict them. If you have an issue, you go directly to them. But be careful, because some children and in-laws and whatever, they don't take our wisdom as grandparents seriously, and then you get cut off. I've seen grandparents get cut off. But I mean, usually in what I see, the parents are more to blame than the grandparents. But there has been, in the cases I've seen, there has been an element where the grandparents, in some cases, if you're watching Mr. and Mrs. A, I'm not talking about you. Recent trial we had for grandparents. Not that you were perfect. Other cases, I have seen that we grandparents are somewhat to blame. So and this is a theme of my talk, you can watch it from my website, as I said, be a peacemaker. Be a peacemaker. Don't be an instigator. Be a peacemaker. Recognize your role. You're not the parent. Parents can do the good things they do, and they can do the not so good things they do, and they can make the mistakes. And be careful when you go to correct your children or your daughter-in-law, your son-in-law. Be very, very careful, especially if the relationship is already strained. If you have a good relationship, it's another matter. But be careful. Be careful.
Right.
You don't want to get into the situation where you're one of those alienated grandparents and you get zero contact. So you can't control what your son is going to do, what your daughter-in-law is going to do, or vice versa. You can't control that. You can't control what you do and what you don't do.
Right. I hear that a lot from grandparents that say, oh no, I can't interfere. I don't want to end up not having to see my grandchildren. That'll break my heart, and it's true, because a lot of grandparents
you have to, for
held.
your children's sake, you have to, for your grandchildren, make sure that you're part of their lives.
Right.
That's it's our responsibility as grandparents. How do the grandchildren know the family history really firsthand? Their parents can tell them, sure, but coming from the grandparents or the great-grandparents, you cannot replace that.
No.
It's there.
No.
And so what the Ontario legislature did, get back to talking about law, after all, I'm a lawyer. What they did was in the section that deals with that you can have that a third party, a person who's not a parent, can have a contact order. It's the Ontario Children's Law Enforcement. They put in including grandparents. Now, so they added 2 or so words to the section. I don't think that did anything. At the time, I can't remember, there was an NPP that had a bill forward that was quite expansive about the rights of grandchildren, to have a relationship with their grandparents. But the politicians wouldn't go for it. And the compromise position was, well, in that section, we'll put it including grandparents can have an access. And many grandparents saw this as a great victory. It's better than nothing. At least it draws attention to the fact we include grandparents, but grandparents were already included. And I know in our talking about this use of legislation, in our practice, when we are approached by grandparents or by parents about troublesome grandparents, we try and find solutions outside of court. Family counseling, constructive involvement of lawyers to talk like I'm talking. Of course, it only works if the other lawyers like me, or like and the lawyers in my firm are like me. So it doesn't work, but to try counseling, everything but court. But sometimes you just have to go to court, unfortunately, and you do.
Yeah.
So if
Sad.
you do, it's very, very sad. But the courts are there so that we citizens do not take the law into our own hands. We have a system whereby supposedly we have to dispense justice. And I suspect out there a lot of you are wringing your hands. Coleman, ridiculous, the injustice that I suffered. There's no justice in the family courts. Well, you know what? I agree with you to some extent. And I understand how you feel. Because boy, oh boy, that system can just grind you up, chew you up, and spit you out like garbage. I know that. I'm talking about. I'm talking now about the theory of the court system. The theory of the court system is such that we have a civilized means of resolving disputes, and sometimes, not always, certainly, the system does work. Far too often, it doesn't work.
It doesn't. When allegations start flying, that's when it doesn't work. When 2 people go into court and say 50-50, does that happen often?
Well, if everyone's agreeing on 50-50, you don't need to battle it out in court, do you?
No.
It's good. If everyone's agreeing on 50-50, it's good to have a written parenting plan in the form of a separation agreement or a consent court order, because sometimes life changes and one parent or the other changes their minds.
Right.
And so you must, in my view is, and not all lawyers agree with me, but I'm right and they're wrong, you must have a legal document prepared by lawyers, properly drafted up, signed, witnessed, so that you have something. And I go even a step further, as I've alluded, you must have a court order, particularly if you happen to be of the male gender, because there is still gender bias in our system, particularly in the system. It does cut against men. Now, I've written on my website, complexfamilylaw.com, about gender bias. I wrote those articles 20 or 30 years ago, probably 30 years ago now. It's not as bad as what I wrote back then. It's gotten much better. But it's still pretty bad in some cases. And you have to be aware that gender bias exists. So for our male clients, our father clients, fine if everyone comes to the table independently represented. Everyone's agreed on 50-50. We can put that down. Do we use our Family Wizard or a similar platform? And what happens if we do have a disagreement about something? What is the dispute resolution process? There is, believe it or not, folks, there is value that lawyers can add. There is. And, if you can't afford a lawyer, well, there is duty counsel at many of the family courts that maybe can help you, and there are great resources online now. Let me refer you to the Association of Family and Conciliation Courts of Ontario, AFCC-O. They have a parenting guide. They have a guide that's available for free online, and they have precedent clauses. So if you can't afford legal counsel to take you through this, use that guide. Now, I don't agree with everything that the guide has, particularly on what? Equal shared parenting. But most of what they have in that guide is very good. It was put together by a number of mental health professionals and lawyers whom I respect, and I think they've done overall a very, very good job. And it's a treasure trove, free treasure trove of precedent clauses. So that's AFCC-O. You just type into Google AFCC-O parenting guide, it will come up. And use that to help you. And then there may be things in there that you and the other parent haven't even thought of. And that will help you get a comprehensive, cogently, intelligently worded parenting plan together. Sign that, and then on consent, get it made into a court order. And if you can't afford a lawyer for that, well, I mentioned the Osgoode Hall Community Legal Aid Services program. It's a class, but still in existence after decades. It's there. And U of T and University of Toronto has it. And I believe, as far as I know, all the Ontario law schools have a student program supervised by a real lawyer, at least. So, access that, access duty counsel. There are resources. There are a ton of other online resources out there. But I think in terms of getting a parenting plan together without the active assistance of a lawyer, there are resources that will help you do that, and you'll have an effective agreement, and hopefully an effective consent order.
While we're on the subject, Vernon Beck from Canada Court Watch, he would like me to ask you what your thoughts are on parenting coordinators.
I love parenting coordinators. And may I mention that Vern Beck's has a service available where his group will provide parental coordination for the lowest price I have ever heard of. You're in that group too, Mary?
Yes, I am, sir.
Okay, so Vern consulted me on this fairly early in the process. I encouraged him to go through with it, and thank God that he has. And just a couple weeks ago, I sent an email around to my entire staff with the link to Vern. And I said, here, let's give Vern's service a try. I don't know if anybody followed up on it or not. But
Brilliant man.
Yes, he is, and so dedicated. And
yeah.
So, yes. Now, parental coordination, PC for short. There are some cases that say that in Ontario, a judge has the authority to appoint a parental coordinator. And there are many other cases that say a judge does not have the authority to appoint a parental coordinator. We just completed a trial in our firm fairly late, I think it was 11 days, and we were pushing for a parental coordinator. And the first reaction of the judge, as my partner, Ms. Colbert-Vade, was giving her opening submission, was, parental coordinator, I don't have the authority to do that. And I wasn't, the trial was online. But anyways, so I didn't hear, I'm going with what she told me. I didn't witness this part of the trial, but I watched other parts. And she said, well, Your Honor, we do have legal precedent on this matter, and I hope that you'll just keep an open mind while we introduce the evidence, and that and if you want to take an advanced look at our authorities brief that we've submitted, you'll see we have the authority there for it. But I will take you through the case law and the arguments as to why you certainly have the authority. Oh, okay, Ms. Fay, continue. The judge, to her credit, did, and thank you, Judge, if you're watching, the judge did keep an open mind, and the decision came down appointing the parental coordinator. And she and in her footnote, when she appointed it, she put some of the cases in our authorities brief, and she added about, I think, 2 other cases that we hadn't found that she did find to support our position.
Wonderful.
So she made this was at the OCJ level, Ontario Court of Justice level, which is fine. Not at the Superior Court of Justice level to be binding on the OCJ. But the OCJ is not bound by anything because you've got SCJ judges saying, yes, we have the authority. No, we don't have the authority. In most of our cases, I would like to say all, but just in case there's an exception, but in most of our cases, we push for a parental coordinator. Because if there is joint decision making, or if one decision is made that the parent has the authority to make, the other side really feels strongly against it. What's the solution without a PC? You got to come back to court. That's expensive.
Money.
And if you're self-rep, it's still expensive. Time off work and aggravation. You have a PC. The role of a PC, let me explain it. Go back to basics for those of you that are newbies to this. The role of a PC is to, one, mediate a solution. In other words, help the parents reach their own solution. That's mediation. Push comes to shove, okay, you can't make nice to each other, you can't reach a solution, fair enough, some situation help. Then the PC changes hats and becomes an arbitrator and imposes a solution. And it's like a court order. And that's it. You have to accept, unless the PC made some huge legal error, that it can be overturned by a court. But otherwise, if the PC follow proper procedures, give everyone an opportunity to be heard and make their full submissions, and then comes to a decision that is somehow connected to the facts of the case, then that's it. So when you know that the person that's mediating your little parenting disputes here and there, PC cannot change the order, by the way. PC can only interpret the order. If you know the person that's mediating, that person is going to give you signals as to what he or she thinks should be the result. You're not likely going to get to the arbitration stage. And if you do, and you get knocked down 2 or 3 times, then you're going to know, hey, maybe I'm not being totally reasonable. Because this person who both sides respected at the outset, and if they had counsel, the lawyers respected to appoint this person as the PC, then you're going to behave yourself. So right. A PC is a great means of parental accountability. And parents have to be accountable. They have to take responsibility for their good decisions and take the reward and the pat on the back, and likewise for their bad decisions. And a parental coordinator keeps everyone honest. And so, yes, I love parental coordination. Hats off to you, Mary, and to Vern, and to others in your group that provide this service. And hats off to the other parental coordinators. I hope some of them may be watching this program eventually. I love you all and really appreciate the great work that you do.
Thank you. And your work too. You know, without your knowledge and your experience and you speaking out on how it can work, people don't believe it until they see it and hear it, right? Because our children are what matters. And if we've got healthy, fit children with both parents, they become healthy, fit spouses and healthy, fit parents, grandparents, future. We got to look at their future, right? On what's happening today, because that 10 years is going to go quick. They'll be opted out of the courts. No one will be there to help them to deal with losing a parent and grandparent. So if we educate our kids today on how, you know, that we're both there for them, and that, you know, we love them both equally. Kids were raised with two parents at the beginning. How is it, they can't handle it. They cannot handle the split. So if we help them move along in the years to come together, it's the best thing for them.
Everything that you just stated, Mary, has been proven, I'll use that phrase again, beyond a shadow of a reasonable doubt by the social science literature as to why a rebuttable presumption for equal shared parenting is, generally speaking, in the best interests of children. I am amazed, though I shouldn't be shocked, but I'm amazed that not all judges and lawyers and social scientists see it that way.
Mm.
When you look at the work of Professor Edward Kruk, for example, that's just one example. You look at his work and his meticulous research, and the works of many others. All right, so people can criticize Dr. Richard Gardner of blessed memory, that he was the first one to talk about parental alienation and the importance of both parents and children's lives. One of the first, and published his book on the matter, and he's been much maligned. But we're way past Dr. Richard Gardner. Again,
Right.
not disrespecting his memory in any respect, he was a pioneer. But we so many more papers have been done and studies, good scientific studies, unlike some out of Australia that are nonsense scientifically, just nonsense and manipulation of data and whatnot. But the good science, not because the result comes the way I want it, but in terms of academic rigor in how you construct your study and how you carry it out and how you report it. It is the data being able to be replicated. All these things that you learn in first year social science courses in university. It's beyond a reasonable doubt that
Right.
equal rebuttable presumption, equal shared parenting is in the best interest of most children. Not for everybody, as I said at the outset of this podcast, but for most, all things being equal. And now, just to give you an example in our practice, today, right now, here are my rough notes. I've been going through the parenting portion of the trial affidavit, evidence in chief of our client in an upcoming trial in the OCJ. I won't say where in the OCJ. And where we are going through all the factors that impinge upon parenting under the Children's Law Reform Act. If I don't get to it, I've got it up here. I wanted to talk about that. At great length to show that equal shared parenting, which in this particular happens to be the interim status quo, but the mom only wants them to have every second weekend. And it's, we could do a 3-page affidavit and say, well, the status quo is equal shared parenting, the 3223 or something, or 323, whatever schedule, like something like that. And it's worked so far, and that's what the trial judge should order. And one can make that argument, we should have done that. But knowing how the courts work, knowing that some people, including some who happen to be judges, don't necessarily think that equal shared parenting is the way to go, we've got to show through admissible evidence what a good father our client is and how equal shared parenting has worked, and give examples from the emails or the text messages between the two of them. He refuses to use our family wizard, interestingly enough, lack of accountability. And why should we have to do that? If we had a rebuttable presumption of equal shared parenting, then we wouldn't have to go through this. Because why? Because both sides negotiate in the shadow of the law. We do not have, neither provincially in Ontario or federally, or anywhere in Canada for that example, a legislative presumption of equal shared parenting. And without the legislation, the fallback practical position is dad gets every second weekend and maybe once during the week, which is not, never mind, not enough for dad. It's not enough for most kids. So we really, really need that. And I want to come back now to this, particularly for self reps. If you're putting forward your evidence, whether it's on a motion or for a trial, and most evidence in chief these days is by way of affidavit. And by the way, when you're doing the trial affidavit, you can't use hearsay. In motion, you can use hearsay. Try to avoid it, but you should, for various reasons, won't get into. But trial evidence, no hearsay. You have to turn, whether the case is under the Divorce Act or whether it's under the Provincial Children's Law Reform Act, turn to section, I'm looking here to my screeners, section 24 of the Ontario Children's Law Reform Act, if your case is Ontario. If you're in Manitoba or BC, you're going to have a similar provincial statute. And in Ontario, and I suspect in the other provinces and territories, your legislation is going to set out what are the best interest factors that we have to apply as a matter of law to determine children's best interests. In section 24 sub 3, it says factors related to the circumstances of a child include A, B, C, D, E, F, G, and all the way down to K. Okay, and J has 2 subsections. So there's a number of factors. When you are presenting your evidence, again, whether on motion or whether on trial, and even and if on trial, if you have to give it verbally, same thing. Keep your eyes on those factors. And if your case is federal under the Divorce Act, don't worry. Even though the Divorce Act doesn't go into this granular detail, the case law pretty well establishes it's the same, pretty much the same factors. So you'll be in good hands to look at section 24 sub 3. Don't go off on what will likely be tangents about what a terrible person your ex is. Focus on the child's needs. Okay, now you want to focus how you meet the child's needs, and you might want to get in some points about how the other parent has not met the child's needs, and you can do that, but don't use bad language, and don't look like you've got an axe to grind, because many of you feel you do have an axe to grind and behave like you have an axe to grind, and you're only cutting your own legs off. Be civil, be child focused, look at the factors in 24 sub 3, structure your evidence around that. And let me make another suggestion, particularly for self-reps. There is a platform, I don't get a commission on this, folks, that I've discovered fairly recently called Perplexity. And then there's Perplexity Pro, which at the moment they don't charge extra to sign up for Perplexity Pro. So I use Perplexity Pro as one of the AI platforms I use. I give it very detailed, granular instructions. Perplexity claims that it does not save your data, and it does not use it to train itself, and it does not reproduce your data or any names out in the world. So supposedly it's private. I would still use letters for names. But in any event, I would put in, like, make a document, a point form document, make it easy for Perplexity about what the facts are. I would feed it. And here's section 24 sub 3 of the Children's Law Reform Act. Please write my affidavit, my evidence in chief. Don't use hearsay. And please write me out an organized affidavit setting out my evidence in a very fair and calm way, and see what it gives back to you.
It's a great idea.
And if it doesn't sound like you, then change the wording. If you make grammar mistakes, put in some grammar mistakes. Make it sound like you, not like a lawyer wrote it or an AI wrote it. I can see when I get applications for junior lawyer positions, articling, law clerk, whatever, I can see that people have used AI because I get the same phrases coming back to me. So I know I'm not interested in those people if they don't personalize it. Personalize Personalize what AI produces for you. Make it sound like you, not like AI.
Right.
But if you feed the AI platform the 24 sub 3 factors, and you feed it the information you have, and then you might want to upload to it some email exchanges or text exchanges and whatever, and give it very specific direction, you will have your affidavit evidence fairly quickly. And hey, maybe I'm putting myself out of business. I don't know.
Wow. That's incredible. We've gone over the hour. I mean, that went so fast, but I just want to talk about.
You're having fun. What's your other question, Mary?
Well, I would just want to mention that you're in the conference in Toronto with a bunch of speakers. Are you not this coming September?
Professor Chung's conference, Men and Families.
Yeah. Yeah.
A previous version of the program that you're looking at has me speaking. I am still proud. I am co-sponsoring that conference.
We're proud too.
But because of pressing personal and business, i.e. law practice issues, I had to withdraw from speaking at that conference, unfortunately.
Oh.
Last 2-3 years, I've been privileged to make presentations to that, speak and hand out papers. But even though I was well advanced on my topic, paternity fraud, another one of my favorite issues, I had to. Well, there's a Yiddish expression. I'll translate it into English for all our listeners. You can't dance at all the weddings.
Mm.
And so I couldn't dance at this wedding, as I realized, and I had to withdraw. So you're looking at an old version an older version of the program. I hope Susan, Professor Chung, has updated it. So no, I won't. But Professor Chung is in the process of putting together a book for publication on men's and boys issues, and I still have my research and have a lot written already. So hopefully you haven't heard the last word on paternity fraud from Gene C. Coleman. Hopefully I'll get that article together.
Well, I'm so grateful that you're here with us today. I mean, it's truly an honor, whether you're in Toronto or you're here. I mean, just to have you and speak with us, alienated parents, grandparents, cousins, uncles, aunts. I mean, it extends, like you said, family. The whole entire family could be erased from a child so that they never know who they are. But
yeah, how many times have we seen the movie Erasing Family and cried?
Yeah.
If you haven't seen the movie Erasing Family, type it into Google, go watch it, shed some tears.
Oh my God, do you ever?
I like the parts in the movie that show that there is hope, even for those erased. There is hope, and I experienced that one time in particular with one of my clients, and I found out, he told me years later, the child turned 18, 19, and he lived in Thunder Bay or Sudbury or somewhere up there. And his child, who he hadn't had contact with in 10 years or something like that, 5-10 years, was at his door. Sorry, Dad, I'm back.
Yeah.
So there is,
I know.
it does happen. But I'm sorry to keep going on, Mary.
It's okay. No, because it does happen.
But those judges and lawyers and others who may say to you, oh, don't worry, don't just give the child some space.
Mm.
She'll grow out of it. Give him 6 months, give him a year. Just step back and they'll get over it, and you'll see everything will be fine. Wrong. Dr. Richard Warshak tells us that is not, and other distinguished academics and clinicians tell us that's not what to do.
No.
In cases of PA, of estrangement, you should consult a lawyer that knows what they're talking about. I'm not the only lawyer that knows what they're talking
Right.
about. But you should consult, get advice of the best way to handle it. But the common knowledge, wisdom, oh, they'll grow out of it. It's just a phase. It's just a function of the divorce. It is a function of the divorce. Just a function of the divorce, and don't worry about it. To give them space, give them time. It's clinically proven to be the wrong advice.
Exactly. 1 day leads to 10 days, 10 days to a year to 10 years, 20
Right.
years. I mean, they're embedded.
We
They're pushed away, and they'll keep pushing and pushing. And
we
unless
tell,
it's stopped,
we tell our clients, and Dr. Warshak covers this off in his book, Divorce Poison, 2nd edition. Divorce Poison, 2nd edition, Dr. Richard Warshak, Warshak. You can get it online at all your favorite places.
yes, everything out there.
And Dr. Warshak says, send a birthday card, send a Christmas card, send a small gift. Is it going to get through? Is it going to be returned to sender? We don't know. Maybe something will get through. In case of teenagers, there's ways to reach out to them directly. Unless, of course, there's an order prohibiting contact. If there's no order prohibiting contact, then as alienated as you might be as a parent or grandparent, provided there's no order prohibiting this, then don't send an email or a text message every day or every hour. No, that's harassment. But you'll be accused of harassment just by doing anything. But especially with older kids, let them know that the parent or the grandparent, of the case may be, still cares and loves them, is interested in them. If it gets through, great. If it doesn't get through, it doesn't get through. But when you meet up with that child later years, you can say in all truthfulness, I sent you a birthday card every year. I sent you a Christmas card every year. I did this. I did that. I've always been there. I always loved you, and I still love you.
Right. Well, Mr. Coleman, this has been an amazing podcast, and you've answered basically everything that a parent or a grandparent would want to ask. And because both mothers and fathers have a special place in a child's heart, and taking one parent from that child only leaves trauma, resentment, and then to deal with it for the rest of their lives is the hardest thing for any alienated child. I mean, I was a daughter of 40 years alienated from my father. I got to reunify with him, but I found him on his deathbed. And we don't want our children, our adult children, to find us like that, because we're all aging out. They may have aged out in the court, but we're aging out in life. We're 60, 70, 80 years old.
Don't remind me.
But we just want to see our kids, just to hug them and hold them. So we're not giving up. We are not giving up. And if we do give up, we're just going to ruin it for the next generation. So this is why I do it.
Never give up.
Never give up.
Never give
So
up.
is there anything, last words you want to give out to the viewers out there? Because I mean, I don't want to take any more of your time. You could always come back and do another part 3 sometime down the road.
Yeah. Okay. Yes, I have a final thought here. Oh my
Okay.
goodness. In our correspondence prior to this podcast, Mary, you asked, how can we help the family court system see it too, referring to the importance of children needing both parents. And you also asked, how do we get the family court judges to make a ruling for both parents without having the child to decide? And any suggestions you make in regards to shared parenting with all members of the family, including grandparents. So, of course, I've covered a lot of that, but keeping those 3 points in mind. Number 1, to answer your questions, legislative reform. Let your member of parliament know that we need a rebuttable presumption of equal shared parenting. 2, Let your member of provincial legislature know. Don't bother your city councillor about this because it's not in their jurisdiction. But family law in Canada is bifurcated between the feds and the provinces. That's a whole topic. I won't get into that now. This comes from historical development, okay? But the fact is, two levels of government that deal with family law. You got to lobby both your representatives. And don't be a pain in the rear. A nice, polite email, a link to maybe one of my articles or other articles, fine. Just let them know. They got to know that the public, by and large, wants a rebuttable presumption of equal shared parenting. And by the way, there are, it's on my website somewhere, there are a number of polls done by independent polling organizations that totally scientific that show the favorability rating, either support or strongly support a rebuttable presumption of equal shared parenting, is between 75 and 80% in Canada. Quebec's the 80%. Ontario, the rest is closer to 75. So politically, it's a good move to support it. That's on the macro level. And when an election comes up, either the province or federally, ask the candidates about this. Make it an issue. There are those of us like Mary, myself, and other people we mentioned here during this podcast who are active doing this. But what really the legislators pay attention to is if they get lots of emails from constituents saying we want this, then it makes our job a lot easier. I just met a few weeks ago, I went with Bijan Rafi of the Men and Families Group to see a local member of parliament. We had a conservative member. We had a very good discussion. Mm-hmm. But him and his colleagues have to receive tons of emails from the public. So that's on the macro level. We need legislative change.
Yes.
And number two, on the micro level, or as I want to reemphasize, like I talked about earlier, organize your evidence, if you're in court, around the legal factors set out in Section 24 of the Ontario Children's Law Reform Act, if you're in Ontario. And number three is how we can get forward, is don't go down and throw the excrement around. Don't do that. As much as you feel hurt and angry, betrayed, disappointed against your spouse, against lawyers, against the justice system in general, your anger doesn't do you any good, eat away at you, and it doesn't do reform process any good, and it doesn't help you achieve the goals in your case. Rise above the conflict, focus on the issues, focus on the legal factors in Section 24, and maybe there'll be some sanity brought back into this whole system.
It would be nice. It would be nice.
Would be nice.
Yeah, it would be. Well, thank you so much, Mr. Coleman. We really appreciate having you today. Any questions? If we have people that want to reach out to you, are they okay to email you, call you?
Hang on.
Retain you?
As I indicated earlier, my ability to do pro bono work on the micro level, individual level, is highly limited, and I don't do it.
No, I don't. I understand that. No, I wasn't pro bono.
As much as I would love to, you can't shut me up. I said I'd stay for half hour, 45 minutes, and here we are. Here we are, 77 minutes later. So, I suggest this, Mary. I'm happy to come back and do another podcast.
Okay.
So send your questions in to Mary, and Mary, when you have a number of questions, we'll have another podcast. I'm happy to do that. Okay.
Perfect.
But do not write me with your individual questions about your
Okay.
case. As much as I would love to answer each and every one of you, I just don't have the time in the day. My wife invited me up for lunch at 12:15, and I wrote, and she also works from home, as do I. And I texted her back. I said, sorry, I can't come. Would you please bring me lunch down to here? And while I was preparing for this podcast, I was eating my lunch. And
Oh,
I haven't even finished 2 of my orange slices. So I just don't have enough time in the day.
I understand. I understand.
I do
Yeah,
have a
just write to me and I could always, bring you back and we could have a whole bunch of questions, Q&A, anytime. So,
happy to do that. Or Mary, I see this platform doesn't seem to allow for question and answers live, and
mhm.
Zoom does. So we could, if you have the Zoom, the upgrade, you don't have to upgrade for all time. You can upgrade for 1 month and then go back down to your regular subscription. But we can, and do I have? No, I upgraded for the webinars that I gave, and I downgraded back. I paid the $25 or whatever. But you can easily upgrade for a month, and you can do it on Zoom. People come in on Zoom. We can see your lovely faces. We can ask questions and back and forth, and that's fine. I can do that. If you want to have a consultation with me personally, there's a procedure for that, and you can make the outreach through through an email from our website, or a little chat box comes up in the texting platform. You can do that too, either way, and we can consider you for a consultation. I can make no promises about the ability to hold the consultation. There's an intake process. We go through it, and those that we think we might be able to ultimately take on as a file, we're pretty jammed up now. But if we think we can take on as a file, then we'll do the consultation, and then at the conclusion of the consultation, we'll jointly decide if this is appropriate for our firm or perhaps for somebody else.
Perfect. Perfect. Okay, we'll get Vernon Beck from Canada Court Watch, set up Zooms. We could do so much with him too.
I'm happy to do that,
Okay.
because I love to talk about family law. I love to help people, and through an open Zoom process, you can help the maximum number of people, and I can learn. The people that call in, and they can learn from me, and those watching can learn. It's a great learning experience for everybody. Mary, again, thank you so much for having me. It's been all my honor to be on your great program.
Thank you so much, Mr. Coleman. Thank you. I appreciate that. So all alienated parents, grandparents, children out there, professionals, thank you for tuning in today on Let's Talk Real Talk. And, we only want the best for our children. And it's always in the best interest of the children. Remember that. Thank you again, Mr. Coleman. Goodbye.